Hello everyone, and welcome to ELI's 2021 summer school session on hazardous waste and sites. My name is Nina Pusick, and I'm the Senior Manager of Educational Programs here at the Environmental Law Institute. I would like to take a moment to thank our outstanding panelists for joining us today to lend their expertise to our summer school session today. This session is on hazardous waste and sites and examines the events that led up to the enactment of the Comprehensive Environmental Response, Compensation and Liability Act, otherwise known as CERCLA. Panelists will explore the legal foundation of CERCLA and also those of the Resource Conservation and Recovery Act, known as RCRA. While I will introduce our moderator briefly, full speaker bios are posted on our website, eli.org, and I encourage you to check out their experience in more detail there. Following each panelist presentation, we will then move on to an open discussion and a question and answer session. You can submit your questions through GoTo's question box, and please do not wait until the end. Send your questions as soon as you think of them. It is my enormous pleasure to introduce and welcome back our expert moderator for this session, Allison Rumsey. Allison is a partner in the Environmental Practice Group at Arnold & Porter. Her practice focuses on environmental litigation and counseling. She previously worked as a trial attorney in the Natural Resources Division at the U.S. Department of Justice and as counsel for the Assistant Attorney General of the Environment and Natural Resource Section. Allison also has worked in South Africa for the Endangered Wildlife Trust and is currently an adjunct professor at Georgetown University Law Center. We are so thrilled to have you moderating for us today, Allison. And with that, I'll turn things over to you. The floor is all yours. Thank you.
Okay. Thank you, Nina. Hello, everybody. So this is, as Nina said, Superfund and RCRA. And at the end, we're going to try to quiz you to see if you actually understand the difference. But I'm going to talk today for 15 minutes or so and give you a very high-level overview of Superfund and how it works. The slides are a little bit more detailed than I'm going to touch on, but presumably you can take them home and then read them at your leisure. All right, so Superfund was enacted in 1980, and it's known as CERCLA. It's known as Superfund. They're the same thing. And I always like to talk a little bit about the history of how it came about. So it was established in response to a number of high-profile incidents around the country where it was clear that people had, or companies and people had been disposing of hazardous substances in various not so fantastic ways that were causing exposures to and dumps and landfills around the country and exposures to people. The first one of the main ones was called Love Canal, which is in upstate New York. I don't know if any of you are from there. This was actually, I'm just trying to get, here we go. So it was actually a canal that was supposed to be a hydroelectric power project. It was never implemented as a canal, but it was sold to Hooker Chemical, and you see the picture here of the big ditch. Perfect place to put drums and waste from your process, which was entirely legal at the time. So they disposed of 21,000 tons of various chemical waste in the big ditch that had been provided. You see some kids playing in that. In 1953, they covered the substances that had been deposited there, and of course deeded it to the Niagara Falls Education Board. And I will say it's not always the case that there is an elementary school at the Superfund site. Sometimes it's a kindergarten, sometimes it's a nursery school. I do have a view that the two things sometimes seem to be drawn to each other. In this case, it was deeded, and in fact, the whole area turned into a community with homes and an elementary school in 1953. There began to be problems as, you know, the barrels leaked and it came up through the groundwater, and it was clear that the hazardous substances had migrated from where they'd been buried into the groundwater and into sort of the basement spaces of the homes. And there studies show that there were actually health effects. And ultimately, 950 families were evacuated from the area, and the site was cleaned up. And the successor to Hooker Chemical paid $130 million for cleanup activities. You know, as a response to this and to several other large similar kinds of problems around the country, Congress enacted Superfund to deal with the problem of abandoned hazardous waste sites. So Superfund deals with a site where maybe there's an owner there or an operator, but they probably don't have enough money to actually do the cleanup, or it's an old landfill, but it's largely, you know, hazardous waste sites that are no longer in operation. Charlotte and Mimi are going to talk later about RCRA, which deals much more with what you're doing when you have a facility that is actually operating and has hazardous waste. That's not Superfund. Superfund is abandoned waste site. So Congress in 1980 enacted the Superfund law to give authority so that EPA could clean up these sites. So what does it authorize? It gives authority to the president to respond to releases of hazardous substances. This is delegated to the EPA. And EPA has a couple of things that it can do with this authority. It can do the cleanup itself. It can go on out and do what needs to be done. More often, well, not more often, it can order the responsible parties, and we'll talk about a little bit later who those are, to perform the cleanup. Or it can enter into a consent decree with the responsible parties so that they do the cleanup kind of more voluntarily than being ordered to do it. This is the cleanup, the technical process in one site. The site, if it's a Superfund site, is listed on the NPL, the National Priority List. And then you go through a process under the Administrative Procedure Act where there's a remedial investigation, feasibility study. You figure out where is the contamination, where has it gone, and at the end of this process you come out, EPA announces the record of decision that says this is how we're going to remediate this site. In theory, then there's NPL delisting, which I would say there haven't been so many of those, although I think we're a little bit getting to the time where that's going to start happening a little bit more. These processes take a long time. All right, there can be a few different things that happen. A removal, which is generally where you know, it's a quick thing and you're removing the barrels. The remediation is the longer process that is, as I said, a remedial investigation, a feasibility study, and there's a record of decision. And in practice, the two things often happen because you might have a site where there are barrels, and so you do a quick removal action, and there are limits of time and money on the removal action. And oops, I think I took out the other. The remedial action is sort of the longer term cleanup, and not just the removing of the barrels. So who conducts the remedial action? As I said, EPA can do it itself and then seek the money from the potentially responsible parties. EPA can enter into a consent decree with the PRPs and have them implement the remedy, and if it gets unhappy with that, it can actually take it back. Or it can issue an order under Section 106 that tells a party to do the cleanup, and if the party doesn't want to do the cleanup, there are triple penalties, and it is not allowed to appeal that until the remedy is actually implemented. Sorry, I'm hoping it's not a little noisy here. All right, so now EPA's decided you're going to do a cleanup, and how does it decide what to do? Many communities want the PRPs just to dig up the entire site and take it all away, but in fact there are 9 criteria that get balanced for selection of remedy. you know, the main one is that it has to have overall protection of human health and the environment. Is everybody else getting feedback, or is it just me?
Hi, this is Nina speaking. I think there is feedback. If panelists could please keep themselves on mute if they're not speaking, it would be greatly appreciated. Thank you.
Thank you. Okay, so there are basically, these are the nine criteria that EPA evaluates. At the end of the day, you know, the focus is on where is the contamination and where is it going to get to, and who are the receptors, which are the people or the animals. And you'll see in this list, again, they can consider costs, they can consider implementability, state acceptance, community acceptance, and there is sort of some larger balance that they try to reach. But you know, the preference is for treatment of the main waste that's a problem at the site, known as principal threat waste. All right, so that's very quick and dirty on the cleanup. And to get to the issue of liability, who's liable, when are they liable, and what are they liable for? So I always think of these as the triggers to liability. Is there a release or a threatened release? And there is case law that says, like, the release can happen because the hazardous substances are blown on the wind. Or there's a case in Montana where the asbestos miners, the asbestos fibers were carried into the town on their clothing. Those are releases. It also can be a threatened release. It has to be a hazardous substance, which is pretty much everything, but not petroleum. You can call me and I'll explain why that is. From a facility, and that evokes a building, but it's really any site where the hazardous substances have been deposited, so it can be a field, and many other things. And EPA has incurred response costs the moment they do the first dollar, and you have to be a covered person or a responsible party. So these are the 5 triggers. Who is a covered person? The covered people are, actually, I think I get to this in a minute, owners and operators of the site, transporters, the truck that carries the waste to the site, as long as the transporter selected the destination, and companies that arranged for disposal of their waste. So if you decide, I got all these hazardous substances here in my garage, and I need to get rid of them, and you call the transporter and tell them where to take it, you are the arranger. All right, liability. In theory, polluter pays, although I will say that I think since Superfund was enacted, it's a lot more of sort of whatever companies have been left standing and their successors. It's a little bit more attenuated than I think it initially was. Liability is strict. It doesn't matter if it wasn't your fault. It doesn't matter if you tried to do everything properly. It's strict liability statute. It's retroactive. It applies to activities that were before the enactment of Superfund. So if it happened in 1850 and it was perfectly legal at the time, that doesn't matter. And joint and several often, although not always, basically everybody is liable for everything. If you gave one drum at the site, you can be asked to pay for the cleanup of the entire site. Very broad liability, very limited defenses. And again, here are the responsible parties: present owner or operator, past owner or operator at the time of the waste disposal, persons who arrange for disposal of their waste, and transporters who selected the site. What do you owe? You owe all costs of removal and remedial action incurred by the government, and natural resource damages, which we aren't going to talk about today. All right, so defenses. There are basically 4 defenses. An act of God. The release has to have been caused solely by an act of God, an act of an entirely unrelated third party. So if it's like somebody you hired and they did the wrong thing, that's not an entirely unrelated third party. You hired them, so that's not a defense to liability. This is really like the person sneaking into your site and opening the drums in the middle of the night, and you took due care to have a fence around your site. A combination of the foregoing and the act of war, which I have up last because, well, we'll get to it. These are not defenses, like the fact that you took all the care you wanted. I've had many a client who thinks it's not fair because they really thought they were sending it to a proper disposal site and it went somewhere else. You know, the seawall was built out of the car batteries. They had no idea that was going to happen. It just doesn't matter. Liability is strict. The act of war defense, there has been one successful act of war defense. It was in 9/11. The owner of properties around the World Trade Centers sued for the owner of the World Trade Center for the cost of cleanup from the toxic dust that landed on the surrounding buildings. And the Second Circuit agreed, in fact, that the owner of the World Trade Center did not was not liable there, that the terrorist acts of 9/11 were an act of war. And that is, I think, the only time the act of war defense has actually been successfully evoked. Sorry, I'm trying to get to the next slide. Act of God, I will say, I think it's an interesting issue, as is climate change an act of God. When you look at Hurricane Harvey and they had the unprecedented flooding in Texas, it actually flooded a few Superfund sites. You know, is climate change an act of God, or is it now foreseeable and PRP should be taking steps to actually you know, or take care of their sites so that they would understand that you might get 50 inches of rain. I think that's sort of a question that we're going to have in the future. All right. I put out a few, in the next two slides, key concepts which you can look at. I just make a couple of points here. One is that if you enter into a consent decree with EPA to do the cleanup, that is entered into court, so there is judicial oversight of your remediation. And there are also sort of de minimis and de micromis settlements where you're a really small player. A lot of times there's an effort to get the little guys out, to give them a buyout. So just the larger companies are involved. There are statute of limitations. I'm not going to talk about that today. If anybody wants to reach out to me, I can explain that, but it was super complicated. The statute of limitations and contribution protection, and when you had to sue under what provision, and then the Supreme Court got involved and made it incomprehensibly complicated, and then they tried to fix that, which made it even more complicated. And more recently, they actually issued a pretty interesting decision about Guam that also relates to this, which is a little bit more understandable, but I think it has led me to believe that we should never have the Supreme Court rule on any Superfund issue, because they make it very complicated and then nobody knows what's going on. All right. Okay, so I would say I just wanted to talk quickly about, I have one more minute before I'm turning it over to Byron. There have been, as I said, so the Supreme Court has ruled in a few instances on Superfund issues, and there is a super interesting case called Atlantic Richfield versus Christian, which is out of Montana. And the fundamental issue here was that for many years, you should all go to it's in Butte, Montana. It's a super interesting site, but it was a huge copper smelter, I think, for many, many years. And there's contamination. There's a large pit filled with water, famous incident where birds landed on the pit and died back in the day. There is contamination sort of around the community. And for 35 years, EPA has been working with the successor to the Anaconda smelter, Atlantic Richfield, to do the remediation. And they came up with, looking at our how do you select the remedy, looking at all of that. And they came up with a remedy for the arsenic and the lead that was in the soil around. And it is understood that you are not allowed to sue to have a different remedy until the remedy is implemented. So, you may not like what's going on, but you got to wait till the cleanup is done, which in many ways makes a lot of sense, or you'd never get any of these cleanups done. In this case, EPA issued the remedy and the community sued under state law for a sort of more strict remedy. It also had kind of been understood, I would say, among practitioners that, there was a preemption issue here. It's an EPA-led remedy, and so EPA federal law applies, and you can't kind of come in with state clauses of action and change the remedy. But 98 owners of the property within the Superfund site in the community brought state claims and tried to get a different remedy with a lower parts per million left in the soil of arsenic and lead. And so here is what the Supreme Court held. The Supreme Court did say that under Section 113, the United States District Courts have original jurisdiction over all controversies arising under this chapter, which I think maybe other people hadn't understood this, but I had always thought that meant, like, for the Superfund site, it's in federal court, it's not a state court issue. But what the Supreme Court said was, no, you can actually bring these causes of action under state law. Which is probably not so good for the PRP here, because they had already spent 35 years and a lot of money doing the remediation, and now you had the community folks coming in and bringing additional cleanup demands under state law for lower numbers, which I think I had sort of thought that wouldn't happen. But the Supreme Court said, no, you can do that. However, they gave with one hand and took away with the other. They also said, but you landowners are PRPs because you are current owners in the Superfund site, and so you cannot do this remedy or insist on this remedy unless EPA approves it. So the view is EPA is actually not likely to approve this additional work, having gone through the whole RIFS and ROD process before. So while it's, probably a loss for corporations who are doing the cleanup, in this case, it may not end up in any additional cleanup at the end of the day. But I would recommend folks read this. It's a very interesting case, and a little bit I would say, like, if you're a company and you spend a lot of blood and treasure and time doing this remediation, the idea that you go through all of that and then at the end of the day someone can come in and say, actually, we want something more and different, is I think going to cause some problem in actually getting cleanups done and getting people to agree to do these cleanups. All right, that's Superfund in a nutshell, and I'm going to turn it over to Byron, who is Senior Counsel in the Environmental and Natural Resources and Government Affairs for the Law and Lobbying Group at Crowell and Mooring. Prior to his current role, Byron served as Deputy Chief of Staff at US EPA, as Senior Counsel for the US Senate Committee on the Environment and Public Works, and as Senior Counsel and Director of Oversight and Investigations for the U.S. House of Representatives Committee on Natural Resources, so a very varied background. And earlier in his career, Byron spent more than a decade as an attorney in the EPA Office of General Counsel. All right, so Byron, I'm turning it over to you.
Thanks, Allison. I hope everyone can hear me okay. Can everyone hear me okay?
Yes.
Okay.
And are you, okay, great, and you can control it.
Yep. Okay, so first I want to thank ELI for inviting me, and thanks to Allison for providing that excellent overview of CERCLA. One of the things that I think is important to remember as we're talking about CERCLA and a lot of the environmental laws is that they're, in many cases, 40 years old, and it's important to remember that our understanding of the laws are constantly evolving due to new judicial interpretations, as well as emerging environmental threats. And CERCLA, I think, is a great case in point that I think a lot of people view the statute as something that maybe isn't relevant to today in the modern environmental movement, but I would argue that it should be front and center, and that a lot of the issues that both Congress and the executive branch are dealing with, as well as communities, are really based on CERCLA or involve CERCLA as well as RCRA issues. And when I worked in the EPA Office of General Counsel, I helped to coordinate the summer law clerk program and the new attorney hiring. And I did countless job interviews with folks over the years who wanted to join OGC. And I was always surprised that I never remembered any students saying they wanted to work at EPA to work on Superfund or even RCRA. Sorry, Charlotte and Mimi. And I just think that that's too bad, because these laws are really interesting and challenging. And I think, as we'll talk about, some of the issues are really cutting edge right now. So I'm going to spend the next 15 or 20 minutes talking about some of the recent legal and policy developments involving CERCLA. As Allison was talking about, the statute has been front and center at the Supreme Court in recent years. So we'll talk about some of that. I'll also spend a few minutes talking about the controversies around the Gold Team mine blowout. It's an interesting case study in, I think, all aspects of CERCLA, from the removal action to literal downstream liability concerns. And then, it highlights the issue of abandoned mines and what to do about that as a source of pollution out west. And then third, I'll talk a little bit about one of the big CERCLA rulemakings that EPA has undertaken in recent years, involving whether to establish financial responsibility requirements for different industrial sectors. And then I'll briefly touch upon some of the other policy issues that are going on right now related to CERCLA, including environmental justice considerations and what to do about the Superfund Tax. So, as Allison said, the Supreme Court has been fond of weighing into CERCLA issues the past, I'd say, 15 or 20 years. I think when people are thinking about environmental cases before the Supreme Court, they're probably thinking about the series of climate change cases, so Mass v. EPA, for example, or even Rapanos. I guess the Supreme Court and its approach to CERCLA, it's not all that different than maybe its approach to the Clean Water Act, where it can be a little bit muddled sometimes, trying to figure out what they're saying when it comes to the different environmental statutes. But I think it's a good reminder that a lot of the legacy statutes are constantly being litigated. They're constantly being thought of in a new light based on a sort of modern day environmental problems, and CERCLA is really no different. So the most recent case that the Supreme Court took up was the Guam versus United States case. And I think it's important to note at the outset that that was a unanimous decision of the court, and it was an opinion by Justice Thomas. Justice Thomas noted that at the beginning of his opinion that CERCLA cases often involve the question of who pays, and the Guam decision is really no different. And this is a case that has been really going on for decades, and involves a dispute between the government of Guam and the United States, specifically the U.S. military, over a toxic waste site on the island that was the recipient of a fair amount of waste from the U.S. Navy. And maybe about 15 years ago or so, the EPA sued Guam under the Clean Water Act, alleging that Guam was discharging pollutants from the site into waters of the U.S. without a permit. And EPA and Guam reached a settlement to resolve the Clean Water Act claims. But after realizing what the Superfund related costs would be, upwards of around $150 million, Guam took action in 2017 to seek cost recovery against the United States. And it initially sought cost recovery under both 107 as well as a contribution under 113. And that set up an interesting scenario for the DC Circuit because it ruled that Guam could have sought contribution under 113, but it could not also seek cost recovery under 107 at the same time, basically saying that those two provisions were mutually exclusive. So the DC Circuit found also that Guam was time barred from bringing the contribution claims because it did not pursue action within the 3 years of the Clean Water Act settlement. So basically, Guam had no legal remedy to pursue some sort of cost recovery against the United States. And I think there's a recognition that was problematic, but that was the way the DC Circuit was interpreting the statute. So the Supreme Court considered the case, and they ended up reversing, finding that that a settlement must resolve CERCLA liability to trigger the contribution protections under 113. So the Supreme Court rejected the arguments from the United States that the Clean Water Act settlement was substantially similar and functionally overlapped with what would have been required under a CERCLA remedial action. So I think that's an interesting case, and as Allison was talking about, the other recent case is the Atlantic Richfield case, and I think she did an excellent job of covering that. I think the only thing I'll add is the interplay with the again with the 113 provision and 107, I think is really an important one that I'm not sure the Supreme Court has definitively settled. If you look at a number of the other Supreme Court cases over the years, they've been focused on who can seek cost recovery, and I'm not sure that they've fully plumbed the depths of those statutory provisions. So I wouldn't be surprised to see more judicial review in the future of those provisions. So I'll move to the next slide. Just moving to the Gold Key mine issue and the issue of abandoned mines. As some of you may know, there's approximately 160 abandoned hard rock mine sites, mostly in the western part of the country. In addition to the physical hazards that these abandoned mine sites pose, many of these sites are also the source of major environmental contamination, especially water contamination from acid mine drainage, and that can have significant impacts downstream from these mine sites. And for those of you who don't remember, the Gold King mine was an abandoned mine in San Juan County, which is in southwestern Colorado. And it's an area of the state that had seen a lot of historic mining activity going back to the 1800s. And generally what happened at the Gold King mine site, I think would make a really fascinating law school exam question. The mine had been operating off and on for more than a century. It had multiple owners during that time. Part of the mine site or the area is privately owned, part of it's publicly owned, a mix of Forest Service, BLM land in the area. So you have a really interesting track record of potential responsible parties. at some point, the mine operations, were going deeper and deeper into the mine, and at some point, the mine operations ceased. This was in the late 1980s, 1991 timeframe, and so the mine was basically closed at that time. Bulkheads were installed over the following years, and with the installation of bulkheads, that led to a backup of the acid mine drainage, filling up the mine works, and caused leakages at different points throughout the mountain. And a couple of the mine sites were getting remedial action under EPA's direction. And in the course of investigating and doing some basic remedial work at those sites, EPA started looking at the Gold King mine site, which was nearby. And in the course of a 2-year period, EPA and its contractors were trying to secure the collapsed mine opening. They were trying to relieve some pressure that might have been building up behind the collapsed mine opening from all this water that had been building up inside the mountain. And one day in August in 2015, there was some sort of action or incident at the site where heavy excavating crew was working and dislodged some soil, and before they knew really what happened, water started pouring out, and within a few minutes, water started rushing out, and over the course of the next hour or so, about 3 million gallons of contaminated mine water was released from the mountain. The videos were very dramatic. The water ended up going into a body of water called the Cement Creek, and then the Animas River, and eventually made its way down to the San Juan River, through the state of New Mexico, the Navajo Nation, and as far away as Utah and Lake Powell. So there were a series of response actions that were happening under CERCLA that led to the blowout with an on-scene coordinator at the site, and then a series of lawsuits filed in the intervening years to try to get cost recovery and damages under CERCLA. So some of the lawsuits were also brought under other statutes like the Federal Tort Claims Act and the Clean Water Act. But the main focus of the discussion here is on the CERCLA litigation. And what's interesting is that district court in New Mexico denied the United States motion to dismiss the lawsuits on grounds that EPA was protected by sovereign immunity under CERCLA, and it basically found that the EPA in the United States may be liable as an arranger, transporter, and operator for the activities at the Gold King mine site itself on that day in August 2015. The litigation has not really focused on what other federal government activities may have contributed to the blowout, and whether other agencies might be PRPs, given their connection to historic mining activities in the site. But at least for EPA, the district court in New Mexico has said that they may be a PRP. The case has also raised questions about whether the contractor operating under the direction of the on-scene coordinator would be liable from immunity under CERCLA Section 119, or whether they would not be subject to the liability protections because they were operating in gross negligence. So that's something that has yet to play out in the courts. There's also been activity to address and remediate not just the Gold King mine site itself, but as I alluded to, there's been a lot of historic mining in that area. So after the Gold King mine blowout, EPA did go through the process of listing the Bonita Peak Mining District on the national priority list. The current owner of the Gold King mine filed a lawsuit challenging the decision. But in 2018, the DC Circuit denied that petition for review, saying that EPA did not need to, and one of the issues was whether EPA needed to go through the scoring process for the Gold King mine site, or whether the agency was within its discretion to evaluate the area as a whole, even though there might be multiple sources of hazardous substances being released, without doing that sort of individual site-by-site assessment. And the DC Circuit said, the way EPA did the listing for the Gold King mine, including the Gold King mine as part of the Bonita Peak Mining District, was appropriate, and EPA had the discretion to do it that way. So as of now, the Gold King mine site is part of the larger Bonita Peak Mining District. There's a few other cases that are going on. As I mentioned, there's cases that were brought by the state of Utah, the state of New Mexico, individual landowners under the Federal Tort Claims Act. Just want to point out that one of the larger cases involved the state of Utah. It was seeking billions of dollars in damages, and that case was settled in 2020 for a relatively small dollar amount, and the commitment from EPA to continue to provide some resources for cleaning up abandoned mine sites in Utah and other areas that might be contributing to poor water quality in Lake Powell. So one of the interesting things that, and if there is a silver lining from the Gold King mine blowout, I think it's the renewed focus on the abandoned mine issue and what to do about it. And on one side, there have been concerns that there doesn't need to be any additional legislative response. EPA has the current authorities under CERCLA and the Clean Water Act to address abandoned mine problems. It's just a matter of resources and maybe agency will to do it. On the other side, there are folks who say, given the CERCLA liability scheme, it doesn't make sense for someone to voluntarily go in and try to clean up an abandoned mine site, through these so-called Good Samaritan initiatives. That the prospect of being liable for any costs associated with the cleanup is just too significant for them. So you have this situation where Congress over the years has considered Good Samaritan legislation that would either provide a carve-out under CERCLA or provide clarity under the Clean Water Act that the activities would be protected. It is really something that has bedeviled policymakers, environmental advocates, and industry for a long time. And the CERCLA issue is really at the heart of it. And one of the concerns, again, could be if a Good Samaritan is working at the site and something goes wrong and there's a release, would they be on the hook for not just the cleanup work that they were doing, but all potential cleanup costs associated with the site. So as part of the legislative debates, there's been a focus on, is there something other than a full CERCLA cleanup that could be allowed? And that butts up against the issues that Allison was talking about, that cleanups have to meet a number of factors, including satisfying all relevant and appropriate federal and state standards. So would you be allowing a lesser set of environmental protections for cleaning up an abandoned mine site, or do you want to insist that the cleanup needs to meet basically full Clean Water Act protections? Another issue that often comes up in the debate is what to do about PRPs, and the general assumption is that PRPs would not be eligible to participate in the cleanup of abandoned mine sites, just sort of anathema to how the CERCLA liability scheme works. But that's not to say other mining companies that might not have a legal liability issue, whether they could participate or not. And one of the concerns that environmental groups have raised about allowing mining companies to participate as so-called Good Samaritans is that they might have a financial, burden, and 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 a financial, interest in remining the abandoned mine site or reprocessing the mining spoils, and so they shouldn't be able to profit from a Good Samaritan project. So there's a lot of interesting policy issues that have sort of prevented the issue from moving forward and being resolved legislatively. The one thing I'll note is that President Biden, in his original infrastructure plan announced at the end of March, would have provided $16 billion to do two things. One was focusing on abandoned oil and gas wells. The other was reclaiming abandoned mine sites. And the bipartisan Senate deal that was announced in June would have supported cleanup of abandoned mines, or cleanup of contaminated sites, but the details are still being worked out, so it's unclear whether abandoned mine sites would be included in that or not. So one other policy topic that's gotten a lot of attention in recent years is EPA's authority and obligation under CERCLA Section 108B to establish financial responsibility requirements for different industry classes. And this is an issue that EPA had not really acted on for many decades since the statute was first enacted. And environmental groups in the early 2000s started challenging the agency for its failure to act, and it got EPA on a schedule to first do a determination that certain classes needed to go through the rulemaking process. And then once EPA went through the process of listing those different industry sectors, which the hard rock mining industry was the first one EPA identified. The other ones that they identified were the chemical industry, the petroleum manufacturing industry, and the electric generating industry. Then EPA was sued to actually go forward and do the rulemaking process for those. And I bring it up in part because it's an interesting example of how policies can change within between administrations. So at the end of the Obama administration, EPA issued a proposal that would have established financial responsibility requirements for the hard rock mining industry. And in the course of the beginning of the Trump administration, the agency reversed course and issued a final action in which it decided not to issue the financial responsibility requirements. And it basically came down to how you interpret risk in the statute and what sort of risk EPA should be considering. Should it be the broader environmental risk, or should it be risk to the taxpayer for having to clean up an abandoned mine site? And so in the final action, EPA decided that they were only going to focus on the degree and duration of risk to the taxpayer from currently operating mine sites that basically the current regime of federal and state regulation of mining activities, including financial assurance requirements from other federal agencies, or under RCRA or state permitting requirements, that those are sufficient to protect the taxpayer from potential CERCLA liability for any currently operating or future mine sites. So the issue was challenged in the DC Circuit, and in 2018, a unanimous panel of the DC Circuit found that EPA was within its discretion to define the term risk in 108B the way it had, regardless of whether they had proposed something different in its proposal, and that the agency was well within its discretion to reverse course and did not need to provide supplemental notice that it was considering a different approach in the final rule. So that rulemaking and the DC Circuit challenge provided the foundation for the agency to go forward and issue no rule regulatory findings for the other three industrial sectors, which EPA did at the end of 2020. I'll note that one of the first things that the Biden administration did on January 20th was issue an executive order directing agencies to revisit all of the prior administration's regulatory actions, and they released a list of about 100 rules that would be the focus of that regulatory review. And the CERCLA financial assurance for the hard rock mining industry was on that list, but I've not seen anything indicating that it is subject to ongoing review. It hasn't been listed in the reg agenda, for example. So that's something to keep an eye out on moving forward, is whether the Biden administration looks to redo any of those regulatory issues. And so just finally, I want to touch on a couple of other issues. I know I'm running out of time, but there's certainly CERCLA policy issues that are front and center in Washington right now. The first one is the Superfund Tax. CERCLA established a Superfund trust fund and a taxing scheme as part of the original statute, and there were some tweaks with the SARA amendments in '86. And generally, the taxes were imposed on petroleum and chemical feedstocks and imported chemical derivatives. And there was also a general tax on corporate income. And that was the primary basis that the Superfund program was being financed for many years. The Superfund tax, though, expired in 1995, and currently Superfund cleanups are generally being paid for out of the general treasury fund that's appropriated to the trust fund, or it's through special accounts, basically settlements that EPA reaches with PRPs, and they direct money into dedicated accounts that can go toward cleaning up sites. So there have been many attempts to reimpose the Superfund taxes over the years, but they've not succeeded. The recent White House and bipartisan Senate infrastructure bill would reimpose the Superfund tax as one of the so-called pay-fors for infrastructure. I would think that would be tied to any plans to increase funding for remediating contaminated sites, but the specifics are lacking at this point, so it's unclear exactly what the so-called pay-fors would be related to the Superfund tax and how broad it would go for infrastructure funding. But one of the criticisms that has been around for a number of years about the Superfund tax is, how broad would it apply, and would it apply to a company regardless of whether they're responsible for future environmental pollution. So you have a lot of industries that would be subject to the tax, but would they actually be, they would be paying the tax, but they also potentially could be a PRP in the future. So does it make sense to go after them at the beginning as well as the end of the process? Another criticism is that it would apply to petroleum. And as Allison said, petroleum was exempted from the definition of hazardous substance. So does it make sense to include petroleum as part of the Superfund tax? There's been a lot of pushback on that over the years, especially since the intervening years. There's been the underground storage tank program, as well as the Oil Pollution Act also has a trust fund. So there's a lot of debate that's going to be happening over the next month or so about the Superfund tax, something to keep an eye out on. Environmental justice is also a major priority for the Biden administration. EPA defines environmental justice as the fair treatment and meaningful involvement of all people, regardless of race, color, national origin, or income, and it applies to the development and implementation of all environmental laws, programs, and policies. So EPA has a long track record of focusing on environmental justice, but the environmental justice has also a long history of focusing on CERCLA and RCRA sites in particular. There's been a lot of concern by environmental justice advocates that these sites in particular have been located in communities with high minority populations or low-income populations, in large part because they don't have the resources to fight these sort of facilities from being located in their communities, and that these communities in particular are recipients of multiple sources of pollution, not just from these sites, but just from other industrial activities and other social determinants of health. So major focus going back to the 80s has been on the role that hazardous waste sites and Superfund sites have, or what sort of impact they have on environmental justice communities. And so in the 1990s, there was a focus in the Clinton administration to highlight environmental justice throughout the federal government's activities. You're seeing a return to that focus in the Biden administration, and Superfund is expected to be a major area where environmental justice concerns will play out. The Environmental Justice Advisory Committee for EPA just issued a report highlighting how Superfund could better incorporate environmental justice considerations, and a lot of the environmental justice concerns focus on public engagement and ensuring that communities that are affected by environmental permitting, regulatory, or enforcement actions are actually engaged in that decision-making process. And CERCLA has a long history under its provisions to incorporate community feedback as part of remedy selection. But I would suggest that with the focus on environmental justice, there's likely to be renewed consideration of whether institutional controls are an appropriate remedy, or whether you should dig out contaminated soil, as Allison was talking about. Whether what sort of role does fish consumption play in determining whether a site is ready for reuse? If a site is going to be the place where people are just working versus living, that leads to different cleanup standards, and I think there's going to be a push to make cleanups more protective of human health, and environmental justice will be a driving consideration for that. And then just finally,
Byron, if you can
Yep.
So I can move to Mimi soon. Sorry.
Yep. Sorry. And just the other hot topic going on right now is whether perfluorinated compounds, specifically PFOS and PFOA, should be listed as hazardous substances under CERCLA. EPA's announced plans to go forward with that sort of regulatory determination, but we're waiting to see what the Biden administration does. That sort of designation would have significant impacts in cleanups and remedy decisions, not just for future sites, but also potentially for sites that have been undergoing cleanup for many years. So it's unclear if EPA will go that route or if they'll focus on Safe Drinking Water Act or RCRA authorities. So sorry for going a little bit long. Happy to turn it back to you, Allison. Thanks.
That was great. I have a lot of questions, but we'll maybe see if the panelists have them at the or our audience has them at the end of the time. So we're going to switch gears a little bit. That was Superfund, as I said at the beginning, largely abandoned waste sites, and we're going to switch with Mimi and Charlotte to RCRA, which, as I'm sure they will explain, has to do with sort of what do you do with hazardous waste in current operations. Mimi Newton is a staff attorney at EPA's regional office in San Francisco, which covers California, Arizona, Nevada, Hawaii, American Samoa, and Guam. So maybe we can ask Mimi about the Guam case. Those were some bad facts for the government in that case. And the Commonwealth of Northern Marianas Islands. Obviously, she has the best region to be in, as well as other U.S. possessions in the Pacific. Mimi started her career in the late 1980s at EPA's enforcement office in D.C., where she worked on a variety of enforcement actions and rulemakings, policy and guidance development involving RCRA. After a brief stint in LA working on environmental insurance matters in private practice in the 1990s, Mimi returned to EPA in 2000. And since then, she does all RCRA all the time. And I will just say that when I teach RCRA at Georgetown, I say RCRA is not for everyone. And so take it away, Mimi.
Little did I know when I was a student at Georgetown that I would be doing this, but you know, I grew up in outside Philadelphia under the shadow of some white hills of asbestos that later became the Nicollet asbestos site, and so I really appreciate what you guys do and that explanation of CERCLA. I thought that was fabulous. Thank you so much. I didn't want to get into waste or CERCLA, just as Byron said, it's not like top of the list. When the EPA asked me what I was interested in, I ranked like climate and air and water, and I think waste and Superfund was at the very bottom of my ranking, so that's where they put me when I joined. You know, why do they ask you what your top preference is when they're going to give you your bottom one? But I'm here to talk about, let's see if I can get this slide going. The Resource Conservation and Recovery Act. It's based on its amendments actually to a statute called the Solid Waste Disposal Act. But my suspicion is SWDA is too close an acronym to SDWA, which is the Safe Drinking Water Act. And that's why we always refer to it as RCRA. Not always. Occasionally you see things, guidance documents that come out referring to the Solid Waste Disposal Act. But the Act has a long history. There were efforts by Congress back in, you know, the 19th century to regulate the disposal of waste in waters and navigable waters. But it wasn't really until the 60s and then the 70s that they really put their heart into enacting what we now refer to as RCRA. And it's kind of a patchwork. You can see even those Superfund amendments and reauthorization in '86 had a little to do. The SARA amendments that Byron referred to, they helped create part of the Leaking Underground Storage Tank Trust Fund that he referred to. We've got a Federal Facility Compliance Act that came out in the 90s that basically said federal facilities, you have to comply with local, state, and federal laws relating to your waste. We have an Energy Policy Act, which amended part of our underground storage tank provisions. And so what I want to do is to kind of give you guys a big overview of the statute and what I do at the EPA. The statute's divided up into a bunch of subtitles, and the subtitles, the ones I focus on are the ones that are highlighted here. We call it subtitle C, addresses hazardous waste, toxic waste, if you will. Subtitle D addresses less toxic waste, maybe. Waste that is more like municipal garbage, things that are not listed as toxic under the subtitle C provisions are listed as hazardous. There's some miscellaneous provisions that we use for enforcement. I'll get into those a little bit, and there's some citizen suit provisions in there. And then there's subtitle I, which is the underground storage tank provisions. And I'll put these 4 subtitles in different buckets, just as a way of explaining them to you. Subtitle C, hazardous waste, is a subset of solid waste, which is regulated by subtitle D. The miscellaneous provisions, the citizen suit authority and the imminent hazard authority can be used to address either solid waste or hazardous waste. And the underground storage tank provisions are different insofar as they really just cover product storage tanks. So hazardous substance storage tanks and petroleum storage tanks are covered by RCRA subtitle I. If they have a release, we can often use the other authorities to address releases of those products, because then they become a waste once they get into the soil or the water. But that's just sort of the general big picture of these these subtitles, and Charlotte's going to get into a lot more detail about subtitle C, which is sort of the big muscle of our statute. And I'll just sort of try and give you an overview. We call it a regulatory statute because we have so many regulations that govern the activities of people who are generating waste and transporting waste and storing waste, and we call this a cradle-to-grave program. I wish that we could boil all the RCRA regs down into a haiku, but the reality is that we've got, I think, what people often refer to as chutes and ladders, a cuckoo land of regulatory programs. This judge referred to them, our regulations, as dense, turgid, and a bit circuitous. So we've had to deal with a lot of complicated, I'm telling you, it's a joy to try to parse through some of these things on a daily basis. It's like a three-dimensional complicated puzzle that you're faced with sometimes, trying to just figure out what the regulations are that apply. And the first subtitle here, subtitle C, gives you a little taste of the dense, turgid, circuitous nature of the regulations. Got my 40 CFR parts listed here. And this is where we find our regulatory program for RCRA subtitle C. As I said, Charlotte's going to go into a lot more detail. So this is really just the bird's eye view. Part 260 has general provisions like our definitions. 261, this is where we identify what is or is not hazardous waste. 262 is the generator regs. 263 is the regs for transporters. 264 and 265 both apply to facilities that treat, store, dispose of hazardous waste. 265 was what we call the interim status regs. Those were meant to apply to facilities that were already in existence when the regulations came into effect. And the 264 regulations provide guidance for EPA on how to write a permit and what should be in a permit for a facility, either a new facility or over time, the interim status facilities were required to get permits if they wanted to keep operating. And these permit requirements typically just apply to the owners and operators of hazardous waste treatment, storage, and disposal facilities. Generators can store their waste without a permit based on how much waste they have and whether or not they're complying with storage requirements. But for the most part, those who store, treat, or dispose of hazardous waste have to have a permit to do so. Part 268 are our land disposal restrictions regulations. So waste that is subject to land disposal restriction has to be treated to certain concentrations of contamination before it can be disposed of in a landfill on the land. And those regulations are all found there. The permit program, Part 270 spells out where, what you have to put in your permit application and how the process for getting a permit works. 271 describes how states can come in for authorization to administer the RCRA program in their state in lieu of the federal program. So if their regs and their statutes are as stringent as the federal program, we will authorize a state program. And then EPA will be enforcing state law in that state. And we've tried to codify which states have authorization. It's not 100% complete. It's really a courtesy under Part 272. There's also 273, which has the regulations for universal waste. And universal waste are ubiquitous types of waste. Again, I'm not going to go into a lot of detail here, but lamps, certain batteries, things like that, that are all over the place. And we needed to create a separate program to deal with those types of waste. There's Part 278 that frankly I'd never even seen before I put this slide together. It apparently relates to a very small program in one particular region that's not mine. And then in Part 279, we have our used oil standards. So that's really a very big overview of, oh, whoops, I'm going back, sorry, taking it too far here. Okay, so subtitle D is the solid waste program. And we also have regulations under subtitle D for regulating municipal waste and other solid wastes that are not hazardous waste. And I put all these regulatory parts down here just to give you an overview, but the two I focus on in my work are highlighted in green down at the bottom. But for those of you who might be interested in some of these others, here they are as references. There's a lot of, and states are primarily the ones that regulate solid waste management and municipal solid waste landfills, things like that. But when you look at the regulations under Part 257 and 258, you have sort of the baseline standards that states are supposed to maintain to regulate solid waste, and those are in the criteria in Part 258. There's also subpart D of the Part 257 regs that regulates the disposal of coal combustion residuals, or coal ash, in landfills and surface impoundments. And this is a relatively new program for the EPA. We promulgated these regs in 2015, and EPA is in the process of putting together a permitting program for coal ash. We proposed a permit program in early 2020, and those final rules have yet to be issued. For those miscellaneous provisions, the first one is the citizen suit authority. And as you can see, there's two basic sections that I've got here. One is the ability to bring a suit against somebody who is in violation of a requirement, or against anybody who's contributed to an imminent and substantial endangerment. And I'll get into a little bit about what an imminent substantial endangerment means in a little while. There's also citizen suit authority to sue EPA when they've failed to undertake a discretionary, a non-discretionary duty. So the typical citizen suits that we see in our RCRA practice are suits alleging a violation of a requirement. And we also have an imminent and substantial endangerment authority at EPA. And we can bring an action, issue an order, require somebody to take action to address any circumstance that may present an imminent and substantial endangerment to health or the environment due to the past or present handling, storage, treatment, transportation, or disposal of any solid waste or hazardous waste. And the phrase imminent and substantial endangerment has been interpreted to mean, you know, it's not like something's going to happen really bad necessarily tomorrow, but if all the factors are in place such that something bad is likely to happen or may happen even at some point decades from now, if nobody does anything, that may rise to the level of being imminent substantial endangerment. And so there's a lot of case law on that question. The last subtitle I'm going to talk about here is subtitle I, the regulation of underground storage tanks. It's near and dear to me because when I started at EPA in the late 80s, this was a brand new program and I was very involved in it. They have, again, regulatory provisions for operating your underground storage tank. And then they have provisions that really aggressively dictate what you have to do if you even suspect that there might have been a release. And as Byron mentioned, there's a leaking underground storage tank trust fund where if there's no one who can take care of the problem, EPA may use its leaking underground storage tank program to clean up a site. There are, again, approvals of state programs under RCRA Subtitle I, and those are in these other parts, 281 and 282. I worked on a variety of interesting cases over my career involving a lot of different fact patterns and a lot of different cases, and I've got a lot of links here for you guys if you want to look at some of the interesting ones. Marine shale processors was a RCRA jury trial. I was basically living in New Orleans for a long time, and it ended in a hung jury. But one of the jury's findings was used as an motion to to shut the facility down. There was a permit denial. There was a lot of different things that went on, and it's still going on. I have a 2006 update, although I was working on this one in the early 90s. I've worked on enforcement actions against the DOD relating to the JCAD's chemical weapons disposal facility. After World War II, the government and all governments around the world collected a lot of chemical weapons, and the US had a disposal facility located out in the Pacific where they were disposing and treating various chemical weapons, including VX nerve agent, which I learned is the human pesticide, and a drop the size of Lincoln's head on the back of a penny inside the Lincoln Memorial will kill an average size human in less than 15 minutes. They were not necessarily doing everything they could out there to protect workers. And so we brought some actions against the DOD for their activities out there. There's a landfill in Southern California I've been working on for 21 years now. So it's almost like a Superfund site at this point, because that's what happens with these big Superfund cases, is they take decades. Some of my leaking underground storage tank sites have taken decades to clean up too, but this one involved a RCRA CERCLA prospective purchaser agreement. It's now being addressed under a state Superfund, but technically we still keep it in our RCRA program in EPA. There's a gas station in Chinle, Arizona that had a huge release after they tried to do the right thing and renovate their gas station, about $2 million. They decided to build above ground storage tanks to replace their below ground storage tanks. And there was a contractor poked a hole in one of the lines leading from the dispensers to the new above ground storage tanks. And that caused a release that was eventually discovered, which had mixed with historic leaded fuel contamination that was discovered in the subsurface. And we knew it had to be historic because it had the leaded fuel. And so we ended up using the leaking underground storage tank trust fund to help address this. And the property operator has been involved in numerous lawsuits in state, federal, and tribal courts against many insurance companies. Insurance companies sued the United States and the Navajo Nation, and it's been a lot of litigation and not a lot of fun. There's also a solid waste case I worked on where we ordered a tire recycler in Southern California to do some proper management of their tires. And this one, we usually don't do Subtitle D work at EPA except in Indian country. So most of my solid waste cases involve Indian country. And lastly, I will leave you with a couple of just resources to go to and to use, places to look for decisions and more information about stuff. Thanks.
Thank you, Mimi. That was great. And it reminds me, as Byron said in the beginning, like everybody thinks the clean air, clean water stuff is sort of where it's all happening. But, the facts of these hazardous waste and RCRA sites are you know, it's every day, it's in the community around you. And I always find like the facts are just fantastically interesting, and things happen that you can't believe it happened. We're going to now turn it over to Charlotte Mooney, who is the chief of EPA's cleanup branch programs in the Office of Resource Conservation and Recovery, which is actually what RCRA kind of stands for. The branch manages the RCRA, the Resource Conservation and Recovery Act, RCRA, corrective action, and PCB cleanup programs. Charlotte has been at EPA for a long time, and we're not going to say how long, and she has worked in just about every area of the agency's waste management program. Prior to EPA, she worked for 6 years in environmental consulting in the corporate sector, and then before that, she ran a chainsaw for the Bureau of Land Management, which I think is very great. So take it away, Charlotte. Thank you.
All right, let's see. Okay, so you guys have heard lots about our cleanup programs in the country, and I'm here to tell you that there's hope for the future, and that the whole purpose of the RCRA Hazardous Waste Management Program is to stop all this horribleness from happening. So we are going to talk about how the RCRA statute and the RCRA regulations that have been developed under those statute is intended to prevent cleanup being needed in the future. And so we all spend a lot of time with very expensive and very complicated and very difficult cleanup activities. It's scientifically difficult, it's really expensive, and very controversial and really unpleasant for those folks who have to live around these cleanup sites. So the hope is into the future, never again, right? That's the idea. So we're gonna just briefly, and I promise I will run through this very quickly, because what I'm hoping is just to give you an overall sense of the program so that you sort of intuitively remember it when you're out doing whatever career you end up working in, because you might notice we all generate waste. Every activity that there is generates some kind of waste. So dealing with the issues of what to do with it and what to do with it properly is relevant to no matter where you end up in your career. So we'll be talking about what is hazardous waste, what's regulated, the definition of solid waste and recycling, just because that interests everyone, because it's fascinating, for me anyway. Subtitle C, corrective action, which is the cleanup program that I manage at EPA. Oh, and actually, Mimi already talked to you about enforcement, so I will not try to do that for you. Basically, the hazardous waste program is really pretty simple. It's basically designed to make sure that the stuff that gets generated ends up in the right place and gets managed properly. So it identifies what is a hazardous waste. It sets up a system for tracking that waste from the point of generation to its final treatment, storage, and disposal. And then it sets up design criteria, requirements for any of the entities in that process. So it's basically a cradle to grave chain of custody system for making sure that waste gets managed properly. Then there's this little add-on, which is the program that I manage currently, the Corrective Action Cleanup Program, which again is preventative. I mean, it's really designed to make sure that those facilities that are managing hazardous waste, we call them treatment, storage, and disposal facilities, clean up any contamination, past or present, that they might have while they are operating sort of going facilities where they have the funds to actually complete that cleanup so that it doesn't end up as a Superfund site. So real quickly, these are a few sort of basic primer about how the program is set up. The statute tells EPA to develop regulations, and we've done a lot of regulatory development. There are pages and pages. Mimi showed you sort of a taste of what the regulations look like. They are long and they are complex. So EPA develops the regulations and then the way the program works, it's a state implemented program largely. So states are authorized to implement the program in lieu of EPA, and it really means that it's in lieu of. So if you're out working with a client and they are operating in the state of XYZ, the regulations they need to be looking at in general are the state's regulations, because the states can be more stringent, first off. And second of all, it is actually the state regulations that are applicable, not the federal regulations. There are some exemptions or differences for that, in that there are a few states who have chosen not to become authorized for the hazardous waste program, Iowa and Alaska. And then there are some states who are not authorized for the entire program, specifically corrective action. There are another 4 or 5 states that have not become authorized for the cleanup program. So it's really important to remember that it's the state regs that govern what your clients or your companies might be doing. States can be more stringent, and then there is built into the regulatory system some site-specific flexibility. So depending on what type of facility you have or what type of activities are going on, there are some opportunities for flexibility in the regulations. Like folks have suggested, it's a complex set of regulations. And then there are some sort of other regulatory programs that address certain wastes. PCBs and asbestos are the most common examples, which are addressed under TSCA. So we're going to start off with, you're running, we have this cradle to grave system. What's covered? What is a hazardous waste? And this is a complex area of the regulations, because you can imagine, across every industry, every activity in the country, many, many different types of materials are generated. So how do you figure out whether it's part of this cradle to grave system? And we'll go into it a little bit more, but this slide basically shows you the first question is it a solid waste? And I'll tell you a little bit more about that. Is it excluded from the definition of solid or hazardous waste? And there are lots and lots of exclusions, So you cannot miss looking through that long list to see if the activity you're working with might fit into one of those exclusions. There are all kinds of things that some of them are industry based, some of them are activity based. There's lots of different reasons, but there are a number of exclusions to pay attention to. So once you've decided that, yeah, you're basically in the system, the question is it a listed or a characteristic hazardous waste? That's what pulls it into being a regulated hazardous waste. And then there's this last little trick that on an individual site-specific basis, a company can apply to have a particular waste delisted if they believe that it doesn't actually pose the risk that the regular listing was based on. So that's a site-specific delisting. So the trick is that folks get very hung up on, and sometimes I think confused by, and then some of us fascinated by, because it is actually a fascinating question, is what is a solid waste? And the statute gives us this lovely definition. A solid waste is any solid, liquid, or contained gaseous material that is discarded. So generally liquids are not considered solid waste, but in the RCRA statute they are, or they at least can be. So the purpose of the solid waste definition is really to help you figure out whether something is a waste. So the solid waste term is a little distracting, I think, but the idea is really just to figure out, is it a waste? Because it's only regulated in this program if it's a waste. So if you're shipping products around the country, that is not a RCRA activity, because those are not wastes. So how do you figure that out? And we'll go through that quickly. And then a waste is determined to be hazardous if it meets any of these criteria, which are basically things that pose a risk. And they're, sort of different criteria for how that's determined, but basically to identify chemicals or waste materials that pose a risk when improperly managed. So there are 2 ways in the regulations that things can be identified as hazardous, either listed or characteristic. And the listed wastes are developed, EPA develops the regulations creating these lists, and they're all kinds of things. They can be sort of generic things from, or wastes from a generic type of process, like let's say electroplating. I mean, tons and tons of different industries do electroplating. So different wastes specifically from particular electroplating activities are listed. Doesn't matter what industry they come from. Then there are some that are listed wastes that are identified to be from particular industries. So only folks in those industries have to worry about those listings. And then there are commercial chemical products, which are basically unused products. So if you have an unused product, it's not regulated as long as you're using it as a product. But if you decide to dump it in the back 40, it's a waste. And although unused, it could still be a hazardous waste if it meets the conditions. These are the criteria that EPA uses to develop the listings. I'm not going to go through them. They're fascinating, though, I promise you. Characteristic wastes. There are 4 characteristics, and these are basically properties of a material that suggests that it would pose a threat if mismanaged, and they're sort of common sense. Ignitability, corrosivity, reactivity. Toxicity is a little trickier. It's a specific test method designed to simulate disposal in a municipal solid waste landfill. So it literally takes a sample of the waste and you put it in a shaker with certain liquids, certain acidity, and then it shakes it for, and I can't even remember how many hours, but literally shakes it for a certain number of hours to try to model what would be the leachate coming out of that landfill. And then you look at the levels of the constituents in that leachate to see whether it's actually meets the characteristic of toxicity. So those are the characteristic wastes. I think I already explained them. You can come back and read these slides anytime you want to. So that's it. Basically, you figure out whether it's a waste, and then if it's listed or characteristic hazardous waste, it's regulated under subtitle C. So that's the first step. And the next question is, who is regulated? Who has to comply with these so complex regulations, which I promise you they're not that bad. Basically, it's a cradle to grave system that tracks a waste through its path from generation, whatever transportation, storage, treatment, and then eventual disposal. The whole system is covered under this cradle to grave system. And overall, I mean, that's basically it, really. If that's all you take away from this presentation, that's it. All the folks that are part of that circular system have requirements that are pretty standard across the entities. Everybody has to notify EPA or the state. They have to get an ID number, which is what we use to do our tracking and data management. They have to use the hazardous waste manifest, which is a shipping document to track the waste, and then they have to comply with the appropriate requirements for their specific entity. The hazardous waste manifest system is a very, it's really very simple at heart, but it requires, you know, quite a bit of information about the quantity of the waste, the type of the waste. It used to be, I think, a 12 copy, that's probably really high. Let's say an 8 copy carbon copy form, and it looked something like this. And now we have a electronic manifest system, which is huge improvement in the program overall, partly because in theory it should be easier for folks to comply with, cheaper for those at least who ship lots of wastes back and forth. And then you also get the opportunity to, you know, hook that manifest system up with your other electronic data management systems, and then there's sort of data across the country available about what's actually happening in RCRA. The way the manifest system works is the generator of the waste, which is defined in the regs to be the person who produces that waste or who first causes it to become subject to regulation. That's a little tricky, but because of the many exemptions, sometimes a material doesn't become regulated until certain management activities happen. There are 3 types of generators, and it's all size-based. They're basically very small quantity generators, small quantity generators, and large quantity generators. Sort of intuitive, right? And guess what? The regulations increase from the very small guys up to the large generator size. The regulations get more specific, but in general, overall, 3 of those categories, it's identification numbers, waste accumulation time limits, and quantity limits that help you define which category you're in. Emergency and contingency plans, inspections, employee training, technical enclosure requirements for waste management units, like let's say a tank or a container storage pad. Compliance with land disposal standards, which is basically a notification requirement to the disposal facility as to what they're supposed to do with the material. And then tracking, the key tracking system, the hazardous waste manifest. So transporters similarly have to have an ID number. They have to follow the cradle to grave tracking system. They're the key actually to make sure that, you know, they sign off when they receive the waste. They get the next person in the chain signature when they pass it on to the next entity in the system. They also have to comply with DOT regulations for all the, you know, sort of safe transportation issues. And then treatment, storage, and disposal facilities is where the waste ends up. So this can be anything ranging from you know, big landfill facility to incinerators to storage facilities, the full range of waste management activities. And there at the bottom of the slide are the criteria that apply to these folks. And similarly, again, it's having an ID number and then complying with sort of basic start to finish safety type of requirements, and then the specific waste management requirements for whatever activity that they're doing, landfill requirements, tank requirements, that kind of thing. Closure is a really key issue, and Byron, I liked your point that clean closure means waste is removed totally and the site is decontaminated. Waste in place closure means that, for example, a landfill, you have waste that's disposed in an engineering system that has post-closure requirements that are to last as long as that facility is a risk of contamination. The difference between those two is huge. You know, if a site is decontaminated and all waste is removed, it's sort of that you're done with it. Whereas a landfill is a very different entity that has to be cared for a long period of time. And I think Byron's point that folks who are concerned about waste management activities are hoping that more removal, clean closures will happen. Financial assurance, Byron also mentioned, is a concept whereby estimates, the facility is required to make estimates of what closure and post-closure would cost, and then provide either insurance or a trust fund or other financial instruments to make sure that that amount of money is available, so that when the facility gets to that point in its life, there's money available to close it out. I'm going to just do this so quickly, largely because it's something I worked on for many, many years. And the basic concept is that in order to be subject to RCRA, something has to be a waste. And you would think that that was easy, but I would ask you to think about your kitchen, and you put all kinds of things into various containers in your kitchen. Let's just say you put that plastic bottle in that nice blue recycling bin. And for these many years, you've thought it was being recycled, right? So you thought that that was clearly a product. That was a plastic input that should be valuable and should be utilized as an input to some kind of manufacturing process. But guess what? Maybe not. So you, the generator, really don't know, unless you know a lot of information about what happens to that material, whether it really ends up being managed as a waste, which is something that nobody cares about and nobody takes good care of, or if it gets managed like a valuable product, which people do care about and do take good care of. So I think that's a really helpful example to explain why the definition of solid waste regulations in the RCRA program are incredibly complicated. And here's an example. This is actually the heart of the regulations, which tells you that you have to know what type of material it is and then what type of activity is actually happening with that material. So if you ever have to read that table, call me and I'll help you. There are certain exclusions built into that table, as well as the ones that I mentioned before, but this is just another example of trying to explain why figuring out whether something's a waste or not is so critical. So this is an example of a material. In the foundry industry, they use leaded sands to make molds. That's those things on the left there. And you can often reuse the sand once you've molded, used the mold to create your metal part. You can break the sand up and then reuse it again. So using lead contaminated foundry sands to make new foundry molds is great. It's a valuable product to that industry. It saves them a lot of money in terms of not having to replace that sand every use. It's very much a valuable product and should not be regulated under RCRA. However, when folks decide to take that sand and they're not so sure that they want to manage it like a lead contaminated material, and it ends up being sold for use as playground sand at your local hardware store, yes, this really happened, then that is not legitimate recycling. It's not management of a product. It is illegitimate recycling, which is considered waste management. So the regulations are designed to help make these decisions, and these are the factors that are used to determine whether recycling is legitimate, i.e. product management, or illegitimate, i.e. waste management. So all this is built right into the regs. The legitimate recycling provisions and the whole definition of solid waste went through many iterations of redevelopment and litigation. But I think it's finally calmed down. I think we finally got to the end point of all the arguments, and what you'll find in the regulations currently is probably about where we're going to be for a while. So I'm just going to super quick tell you about my program, the Corrective Action Cleanup Program, which applies to treatment, storage, and disposal facilities. So that's all your landfills, storage facilities, incinerator facilities, any type of waste management facility. And it basically was added into the statute. That's a map of our roughly 4,000 facilities that we're currently focused on cleaning up. Did you hear that number, 4,000? It's a lot. And they're located in a lot of communities. So the corrective action provisions were added in the Hazardous and Solid Waste Amendments of 1984. Those are the provisions there, which basically require treatment, storage, and disposal facilities to clean up contamination, whether it was past or ongoing. And it's an interesting corner of the regulatory program because there are almost no regulations. Unlike the definition of solid waste and the rest of the regulations, the RCRA regs that go on for pages, the corrective action program is really basically one provision, 264.101. And it is very general, and it basically says these folks have to clean up contamination. And the program is very much modeled after the Superfund program. And basically you have to identify releases from management units, characterize the contamination, identify possible remedies, make a decision about what remedy you're going to implement, and then go ahead and do so. This is something that is kind of interesting. I don't know how many of you all will end up in sort of environmental program management, but one thing that's really important is measures. How do we know whether our programs are doing anything? And these are, I think the corrective action program, and actually all of EPA's cleanup programs use similar ones, are really effective measures for telling whether your program's doing something or not. And for our program, we have these environmental indicators that human exposures are under control and migration of contaminated groundwater is under control. So these are facility specific. So for any one cleanup, has it met these measures? Has the remedy been constructed? Ready for anticipated use is sort of like, is it ready for redevelopment? And then performance standards attained, has the cleanup been completed? So these are very effective measures that we use across the program. That's RAU. And this is a slide just showing you over time the corrective action program of our 4 main measures, how over time many facilities have actually met those facilities in cleanup. And so we're always aiming to speed it up, get it done faster, and get more facilities to the end point of having been cleaned up. So that's it. There's my contact information. Please feel free to give me a call anytime you have a RCRA issue. I'm happy to help you find the right person here at headquarters, although I will caution you, the first question is probably going to be, and what state are you working in? Oh, you might want to call your state contact, but we're always happy to help you find out who that is. So that's about it.
That's great. All right. Well, thank you, Charlotte. That was great. I may call you for getting ready for my RCRA class next year. So there are a couple of questions, and so I'm going to go through them. About 3 or 4 of them actually, in various forms, ask the question of what was the source of the petroleum exclusion to Superfund. And I think I know the answer, but I'm wondering if anybody actually knows the answer to that. All right, so I'm going to attempt to answer this. My understanding is that when they were coming up with Superfund and doing the list of hazardous substances, somebody said, was it the influence of the oil industry or the gas industry? It may have been, but there was also, I believe, and Mimi may know this, like some concern about underground storage tanks at gas stations, which are basically, at that time, were kind of leaking all over the country. And there was some concern that the Superfund program, if petroleum was a hazardous substance, would really become a program about cleaning up underground storage tanks. I will make 2 other points. One is that if your petroleum has any other hazardous substance mixed in with it, the petroleum exclusion does not apply. And so I've spent actually a lot of time at different Superfund sites where we are sort of looking at somebody claiming the petroleum exclusion, but they also have added PCBs to their petroleum. So that is, the petroleum exclusion no longer applies. And then the last point on this is there is actually, it doesn't mean it goes unregulated. There is an underground storage tank regulations under RCRA, which Mimi and Charlotte could probably talk about. And there's also the Oil Pollution Act, which was enacted in 1990, which I know something about, which has to do with oil spills. So, you know, in a particular context. So it's not that it's just off the table, it's just that Superfund isn't really going to be used to do those cleanups. I don't know if anybody disagrees with that or has a different view. So the next question, and oh, go ahead.
Well, I was just going to say there are exclusions under RCRA subtitle C for media, meaning soil or groundwater that's been contaminated by the release of an underground storage tank, petroleum release, for example, and they apply to certain waste codes associated with certain toxicity levels. There is also a case out there that says that once the petroleum is released from the underground storage tank, it is a solid waste. And that's an old case, Dans versus Nelson. That's it, over.
Interesting, I didn't know that. All right, so question, has there ever been a requirement for industries to be required to have certain levels of insurance to assure financial coverage of CERCLA type cleanups? Again, Byron, do you want to answer that one? I think it really goes to the issue of financial assurance. If you know.
I would say not under CERCLA, at least for the non-transportation provision that EPA is responsible for. I know the RCRA context, as Charlotte was talking about, is different, and there are also, I believe, with the focus on the hard rock mining sector, for example, one of the factors that came into play was the financial assurance provisions that other regulatory agencies, the Forest Service and BLM, have in place to govern the financial impact from mining activities on those federal lands. But beyond that, I'm not familiar with anything.
Yeah, so Superfund does have financial assurance provisions, and you have to provide financial assurance that you can pay the cost of the cleanup. And you have a few ways of doing that, one of which, you know, there's self-guarantees, you could get bonds, or there is insurance that can be expensive. And I believe, Charlotte, that, right, and Mimi, that RCRA has the same financial assurance provisions.
For treatment, storage, and
Oh, yeah.
disposal facilities, yeah, for closure and post-closure.
Yeah, so the answer is really, there's not an insurance requirement, but there is a financial assurance requirement that generally does the same thing, unless you're in hard rock mining. Okay, so how are Superfund sites identified? Does anybody want to take that one on? All right, so I will say that in the early days, states, I think, were allowed to, each state was allowed to sort of say, these are the 2 sites we want. And since then, there is a whole process for ending up on the NPL, which basically looks at, you know, what is the waste that you have there. There's a big emphasis on where is it going and what are the so-called receptors, which are like, are you out in the middle of the woods and nobody's going to be impacted? Or, you know, are you in the middle of a community and the people are the receptors? And you get a hazardous waste score, which I think I'm saying that incorrectly. It's driven a lot by groundwater as an input and by the receptors. And if you get over, it used to be a 28. I don't know if it's still a 28. If you get over a 28, you're on the NPL. If you're not on the NPL, it doesn't mean you go unabated. It probably means that you're going to fall under some state program. Okay. And then a question that I think probably goes to both CERCLA and I think RCRA, is there a time frame for hazardous waste cleanup? Is there a statutory time frame either under Superfund or under RCRA that says you start on day 1 and you have to be done by, you know, X plus? Does anybody, Charlotte, what's your answer to that?
I think that's a great idea. Let's do it.
Yeah, exactly. I think that you would probably get everybody agreeing that that would be great because, you know, on the regulated community side, you know, you're 30, 35, 40 years into it. And it is, in fact, why I think state cleanups, if you can get your remediation under a state program, that's often a little bit better because with no disrespect to EPA, it tends to be a little bit faster by a lot. But there is no actually statutory deadline that says you have to be done. Okay, so Charlotte and Mimi, how does EPA deal with states if they do not comply with the RCRA management requirements? Is there a certification process for the states, or do they rely on citizens to report their state governments for failing to comply with RCRA?
Well, we do have states that own facilities, maybe operate facilities similar to federal facilities, and we treat them just like everybody else. You know, they have to comply with the regulations, and you know, obviously it can be a little bit more political, but we will inspect those facilities where they're treatment, storage, and disposal facilities on a frequent basis, and take enforcement as appropriate. So in terms of whether they have to adopt the whole RCRA regulatory program, that's a separate question. They're free to do that or not. You know, I do have a couple of Pacific Islands, you know, who are territories and defined as states under RCRA, who, you know, have sought authorization a long time ago or are not interested in seeking authorization because they don't really have a robust program on which to rely. So our Pacific Islands office, for example, does a lot of work on the islands. I don't know, Charlotte, if you want to add anything to that.
No, just that, I mean, we do have an oversight role with the authorized states. So there is an oversight, first, initially to ensure that the state's program is equivalent to the federal program, and that, as an example, that they have sufficient enforcement authorities and resources to actually implement the program that they get approved for. And we do some oversight of that over time. That's the process. That's how it's supposed to work.
And again, I'd say as a regulated entity, you do worry if you're with the state and the state's not being tough enough. Maybe that's great, but you also know that you know, EPA can come in and overfile and kind of bring the hammer down. So it's not really in anybody's interest to have the states not doing what they need to do.
Right.
All right, so there's another question here which I think is interesting, and I don't know the answer to this exact question, but I have a view on where it goes. So does EPA authorize the use of PFAS during fracking? And if so, how so? Does anybody know whether, I don't even know if PFAS are used in fracking? All right.
There was an
the,
article I think there was an article yesterday in the New York Times about this, so I will refer people to that.
All right, read the New York Times yesterday. The only thing I would say is I think there is a view in the world that all chemicals and things are regulated, and PFAS are unregulated, as Byron pointed out. It's like an unregulated compound. And, you know, today's not the day for a TSCA class, but, you know, how things are regulated and what is regulated, you know, there's a process for that. TSCA was renewed to try to make it a little bit more efficient. But it's possible PFAS are used in fracking and that it's an unregulated compound at this moment in time. And maybe that will change, but, you know, that's the world that we live in.
I'll also point out that under RCRA, there's a statutory definition of hazardous waste and there's a regulatory definition of hazardous waste. So EPA has very tight restrictions on the regulatory hazardous waste, but it's always important to take a look as well at the statutory definition, which may, in some instances, be broader than the regulatory definition.
Yeah. I also think that you could use, and you guys may know better than I do, you can use 7002, you know, imminent and hazardous endangerment, and I believe I've had matters where that has been used, where it is an unregulated compound, but, you know, EPA can use its RCRA 7002 authority to sort of, you know, make you do something about what's happening.
I'll correct you there, Allison. It's 7003. That EPA,
three, yes.
7002 also has an imminent and substantial endangerment authority for citizens to use.
Oh, you're totally right. 7003 is EPA's authority to come and make you do something. All right, so I think that we are out of time. And here is Nina back. Thank you all.
Perfect. Thank you so much, everyone, both to our panelists and for our participants for joining us today and for your excellent questions. Unfortunately, we did run out of time, but thank you all who have submitted your many questions. We hope that you continue to join us throughout every Tuesday at 12 p.m. Eastern Time for the next 2 weeks as we near the end of this year's ELI Summer School Series. Next week, our expert panelists will be exploring products regulation, and we so look forward to seeing you there. Finally, an enormous thank you to our outstanding panelists. We appreciate your contributions to today's webinar and thank everyone for lending your expertise and insights and experiences from your career to make this such a fascinating and informative summer school session. Thank you all again and stay well.
Thank you. Bye-bye.
Bye-bye.